We welcome you today to the webinar of the new Employment Equity Act in our country, specifically tailored for this presentation will be specifically tailored for the South African property market. We are honored to have all of you join us this morning as we delve into this crucial legislation and its implication to our industry. The Employment Equity Act represents a pivotal framework aimed at fostering fairness, equity, inclusivity within the workplace. As a Department of Labor, we recognize, they recognize the significance of ensuring compliance with this legislation and its role in promoting diversity and transformation across all sectors, including our sector, which is the property sector as well. Throughout today's session, we will explore the key aspects of new Employment Equity Act, providing insight, guidance, and practical strategies to navigate its requirements effectively. Our objective is to equip you with the knowledge and the tools necessary to embrace diversity and empower your workforce and drive suitable growth within your organization. We encourage you to be active participants, engage, and let's have the dialogue throughout the webinar. And as we aim to foster collaborative learning environment where ideas can be shared, challenges can be addressed, and solutions can be defined. Once again, thank you for your participation, and we trust that our webinar today will be both informative and enlightening as we embark on this journey towards a more equitable and inclusive future of the South African property sector. With that said, I would like to introduce Director Masilo Lefika, who's the DDG at the Department of Labor. He'll be joined by a few of his colleagues as well. He's responsible for compliance and legislation in the department with a specific reference to this legislation. Director Lefika, can you hear me?
As I've been introduced, my name is Masilo Lefika. I just want to put clarity there. My designation is Deputy Director. So I'm in compliance and monitor under employment equity, dealing with monitoring and compliance. But our compliance and monitoring is not like inspections. It's just that we are more of policy making directorate. We're working together with the Commission for Employment Equity. Therefore, we are the ones, and driving this issue of policy development as such. Therefore, when I'm saying monitoring is through when you submit your annual reports, then we consolidate and then come with the Commission's report. But my presentation today, colleagues, thank you very much, is that the overview of my presentation, much as I've seen from the webinar, it's more about the new amendments. So I'll cover just a small portion of the last report released by the Commission for Employment Equity last year. We're still waiting for the 24th Commission's report that will be released soon. So there were just two levels I want to touch on. Then I will deal on with the employment equity amendments and the sector targets, and then I will reflect your targets in the sector and the way forward. First of all, we know that we're talking about transformation in the labor market. I just want to put a glance on that we do have a benchmark in the country that is the economically active population, that is the EAP, which is composed of covering people that are between 15 and 64 years old, and then not the census as such. I think most of you know about the economically active. That is the benchmark reflecting the demographic of the country, and it covers those that are employed and those that are unemployed but seeking for employment. These statistics, we get it from State South Africa. We get it from them. They are the ones that deal with this the EAP statistics. So you're looking at the stats here, it will reflect that Africans, this stats was for, we normally use the third quarter that end in September each and every year. So in the next 24th annual report of the Commission, we'll be using the third quarter for 2023. So it has not been released now, but based on that, normally the EAP is just a fraction of changes. The picture is still the same, reflecting that Africans are at 80%, colored 9.3, Indians 2.7, white male at 8.8%. But this one is a national EAP code. So remember that when you do your analysis and the rest, you take also the provincial EAP into account. But what I want to emphasize is that the Commission for Employment Equity in all the reports, about 23 reports since 2000, they're releasing the report. They reflect that the picture is not changing. That at top management and senior management, professionally qualified and skilled management, the picture is not changing as such. And then that is why I'm sharing with you. I'm going to share with you on the only 2 levels. I don't want to waste time on that. It reflects that at this level, you can see the purple. I'm not good in colors. White groups are at 62.9%. And then you look at Africans are at 16.9%. So this is the picture that is being reflected in the last report, the 23rd report of the Commission, just to show you that there is no change as such at top management. More in particular, looking at the demographic of the country. But I don't want to dwell much on the levels. I want to go to the gist of this issue, but I just want to give a background. Also, the same picture appears as senior management. These are the critical levels. However, the Commission, the Minister setting targets its own 4 occupational levels, which I will share with you, colleagues. Then, when it comes to the issue of the EE amendments, you'll recall that the amendment bill was signed by the President into law. So now we do have the Employment Equity Amendment Act 4 of 2022. But the issue with that Amendment Act is that it's not active now because the President needs to gazette the notice page that reflects the commencement date of that Employment Equity Amendment Act. So it's not signed. Therefore, we cannot up to now implement the act as such. That's why now we're doing broad consultation on the amendments. But what is carried in the EE amendment, it's very important, and the purpose of this amendment are as such, the key objectives saying that the amendments are there to reduce the regulatory burden on small employers, small businesses. That means that those businesses that employ less than 50 employees will not be regarded as designated employers. Designated employers is nothing else but employers that employ 50 and above, and those that employ less than 50 employees, they become designated in terms of their annual turnover. You will check under Schedule 4 of the Employment Equity, it lists those ones. For example, in agriculture, the annual threshold or turnover is 6 million. And therefore, meaning that if a company is within that sector and has got less than 50 employees, but the annual turnover is 6 million and above, will be regarded as designated employer. That is the current law before the amendment, that one, the one we are operating on now. But with the amendment, when they come into operation, this 1.49 will not be regarded as designated employers. The minister, the Amendment Act empowers the minister through consultation with the commission to set sector numerical goals in order to ensure that there is equitable representation of suitably qualified people from the designated groups, and also to promulgate Section 53 of the Employment Equity Act in order to issue EE compliance certificate, meaning that Section 53 was not promulgated, but when the amendments are going to kick in, it will be there, and it's going to allow employers to report and to get EE compliance certificate. But there are criteria that should be met before getting the EE compliance certificate. That means that when the amendment the date of commencement ensues, we will also publish the bigger regulation that carries all the templates, the forms, then you will see in that regulation. So, and I said that there are criteria. There are two criteria here to get EE compliance certificates. Much as small employers that employ less than 50 are being, they are no longer going to be designated employers. They are not going to submit the reports. But the issue is that if they want to make business, remember the EE compliance certificate is for organization to be able to make business with any organ of the state. So in other words, it will be a prerequisite to access to state contracts. That is the main issue with the EE amendment, Section 53. So much as employers with less than 50 are not going to get certificate, not going to be designated groups, but they can request certificate. But before they get a request certificate, e-compliance certificate, they must comply with the two criteria, that they must comply with the national minimum wage, paid minimum wage, and also must not have unfair discrimination case or award from, as an employer from the CCMA. And we're looking at the 12 preceding 12 months of reporting. And also the other issue is designated employers, those that will be employing 50 or more, they've got 4 criteria to meet in order to get compliance EE certificate. That means they must also comply with the national minimum wage. They must not have unfair discrimination award from the CCMA. And then also the most important one, they must submit the reports and comply also with the annual EE targets that would have been set by the minister for 5 years. Remember, the 5-year sector targets, it's more like a goal, meaning that it's there in year 5. So employers will be allowed an opportunity to set their own annual targets as milestone towards achieving that particular goal of 5 years that the minister has published. So I want also to touch on the issue of the unfair discrimination award. When we talk about 12 months not having an unfair discrimination award, we're talking about finalized award by CCMA or the labor court. We don't talk about cases that are still under review or there is an appeal. If that is still an appeal, that means it should still be positive on the employer to also get certificate on that. So there is also the issue that we want to clear up, that the sector targets are not quotas. There is a difference there, that quotas and sector EE targets, because the targets, these targets, they are not quotas in the sense that you as an employer, you have the opportunity to set your own annual targets, and you will be measured on your own annual targets that you have set. And then when you measured on those annual targets that you have set, you meet those targets, you also get a certificate. So you see that it's you setting your own targets, your milestone that you will achieve in order to get certificate. On an annual basis. Certificates will be on annual basis. So quotas are not, quotas are more rigid. They are not flexible, but these EE targets are flexible because you check under Section 53 of the Employment Equity Act, it's clearly prohibiting the issue of quotas. That the quotas is that they are just rigid. They are not, they are really protected, prohibited by the Employment Equity Act. And then under quotas, you don't have even justifiable reasons. You just have to do it or you don't do it, or you are punished on that. Sector EE targets are benchmarks. These are flexible, as I've already said. And this, if you look at the targets that you have also are in the sectors that have been proposed, the proposed targets, they are just minimum targets as such. If any company or a company go and do analysis, most of the company, they will see that they've already surpassed the targets. And then, but the issue is that you have to move towards the EAP, demographic of the country. So, as I've already said, that the targets are flexible because designated employers still maintain power to consult employees. You're self-regulated on your annual targets towards achieving the 5-year targets that have been regulated by the minister. And the other important thing is that when we say they are flexible is that if you fail, you as an employer, you fail to set, to meet the target, the annual target that you have set yourself, let's say for next year, you said you want to achieve 10. You fail to achieve your 10 after you have done your analysis. The law still permits you to raise justifiable reasons. And those justifiable reasons, they will be listed in the regulation that will be publishing the big regulation that carries all forms. It will be, they will be issued in order for you to comply and get a compliance certificate. So these are not quotas. You set your targets, you fail by yourself, you still got we provide you with justifiable reasons. Give us justifiable reasons. They are more lenient. So those justifiable reasons are here, colleagues, in the next slide, that failure to comply with EE targets that you as an employer have set for that year. These are targets, justifiable reasons. And these have been communicated, deliberated at NETLEC, and have agreed upon that employers, let's not bottleneck, the employers, let's give them justifiable reasons. It might be the issue of insufficient recruitment opportunities or promotion opportunities were not there, or while you are having your affirmative action measures whereby you train in designated groups so that they've got the skills and experience and qualifications, you are still cooking that pot, but it's not yet readily available. It might, and then there are opportunities. You might come and say insufficient target individual from those that you are empowering. And then the CCMA court order can raise that one. And transfer of business. If your business, there's a transfer issue that you are unable to meet that. Acquisition, maybe the company is merged while already you have set the target, and then you are unable to achieve that target. Or we know very much that there was an impact of the COVID-19 on businesses, Some have closed, some are still trying to stand up and then move on. And those issues are taken into account as justifiable reasons. So there's no hard feelings for employers. The justifiable reasons are there. You are still setting the target, but through consultation processes. And then, therefore, these are not quotas. The next slide, colleagues, is that sector stakeholder engagement. We started this process 2019 of broad consultation, and we are still consulting even now. And then submission have been submitted. We have deliberated. That's why we have consolidated and tried to publish the proposed targets. But the issue is that when the targets were set, they were not set like haphazardly, just to say, yes, this is property. We think this should be the target. So we looked at the EAP, we looked at the various sector charters, sector codes. We looked at the workforce profile of the sector at that particular time. We took the 2022 workforce profile and say this sector is really at lower. I mean, there's not much of transformation, therefore. We cannot set high targets. Let's set reasonable targets that they will try to meet in 5 years. And thereafter, we'll review and see if we need to move and increase that target or reduce the target. And the unique sector dynamics were taken into account. The real estate sector dealing with property more in particular, it's not like the agricultural sector. You're not like the mining sector. So there are different unique dynamics, sector dynamics that were taken into account, that much as they are all sectors, they cannot move at the same time to reach the EAP. Therefore, this sector have got these challenges here, then the target will be in this fashion. Then the last bullet says that transformation must take place through natural attrition. What we're saying is that no person will say that you're gonna terminate other people or retrench with them in order to reach the employment equity targets. Employment equity is about natural attrition. Natural attrition in the sense that, yes, Masilo, you are about to retire next year. That is an opportunity to say that if the Masilos are overrepresented and females are underrepresented women, then when that person leaves, then is an opportunity to address that gap, that the underrepresentation of women. That means it's through natural attrition, or when an organization expands, there might be opportunities. If the structure of expand, there will be opportunities, and therefore can be utilized to address the underrepresentation of the designated groups. Or people just resign. You know, the other thing is just people, we are not here to live for long. We might move on, pass on. It's much of the issue of addressing the issue of underrepresentation of the designated groups. And here, colleagues, here in this slide, I've tried to share with you the slide for the real estate. You know, what happened is that maybe I should do this. What happened is that on the 12th of May 2023, we published a sector regulation, the regulation reflecting the sector targets. And then we were given 30 days to get the response. So we got the responses, the submissions were made, then we revised that target, I mean the targets as such. Then we republished the sector targets regulation on the 1st of this month. We got about 21 days now since we have published that regulation for broader consultation, and we are waiting for submissions from different sectors individuals, academics, so that you submit your submission of the proposed sector that we have republished. So they've been republished for 90 days. So this will end up somewhere on the 2nd of May. So you still got ample time. You sit in your forums, discuss those regulations, give us submission so that we consider when we finalize the final regulation of the sector targets in different sectors. So you can see here, we said top management in real estate, 45%, of which 20 should be female, 25 male. And then at this time, I'm going to share with you the difference after this, the difference of the first draft of proposed target regulation that we have published last year in May, and the current one that is in for public comments. The difference there, what have we worked on? So this is the targets in your sector. What happened here? Let me go to the slides, we'll come back. So the changes that we have made in the republished draft regulation of the proposed sector E target is that in the previous one, the proposed sector targets we distributed in terms of African, colored, and Indians, race, and gender as such. But now there's no racial distribution of sector targets. It's one sector targets for designated groups. And you'll recall in the previous one, we said blacks, but now we took it in line with the law that says designated employers. Designated employers designated groups include blacks. Within the black is African, colored, Indians, women, and persons with disability. So it's defined in the law. Therefore, the target is set on that, meaning that if you are an employer, when you do your analysis, there's underrepresentation of a designated group, you need to set the target there. Therefore, you cannot set a target to those groups that are overrepresented, irrespective whether they are African, colored, Indians, women, white groups, or whatever. If they are overrepresented, you cannot perpetuate setting a target on that. And then in the previous one, there was no clarification on the factors to be taken into account. But here in the regulation, if you look into it, there are factors that I've already alluded that we have taken them into account: the workforce profile, the EAP, the charters, the codes. So those are the factors that we have taken them into account. And then the previous one, there was no clarification on implementation of EE affirmative action. If you check under paragraph 4 of the current regulation, the republished regulation, there is a clarification provided there of the draft regulation that there's no one that should be dismissed or the issue, in order to reach affirmative action. And also remember, the department has made, there was also deliberation, a case, that was raised by the Solidarity, that were, with the ILO, and then the ILO referred the matter to our CCMA so that we sit with Solidarity to iron out the problem. So the issue that has been they've raised, we did have the settlement agreement between the department and then Solidarity. So those that the information, the contents of the settlement is also covered in the republished regulation. So that is the most important thing that we want to share with you, that will be taken into account, that there won't be any issues like obsolete barriers that may be placed upon employment practices affecting any person from any group as per section 15.4 of the Employment Equity Act. You go through the regulations under paragraph 4, we have listed those information. And the other one, no justifiable reasonable grounds for non-achievement, non-compliance with the sectors. So we have included there, you can check under also paragraph 4.5 that we have listed the previous regulation. We didn't list the justifiable reason. We thought that would be in the regulation, but in the bigger regulation. So it will appear in both, in the sector regulation and the bigger regulations. Those are the justifiable reasons that I've shared with you. And then the other one, yes, there was no clarification on the termination of a contract or dismissing people to achieve affirmative action. So there's clarity in the republished regulations that no person can be removed, no employee will be dismissed in order to try to bring other people in order to achieve affirmative action. So that is not allowed in employment equity, but you know very well the issue of dismissal and what is more attended by the labor relations. People can be dismissed because of operational requirement. That's still with the labor relation, but not for employment equity, whereby you said you terminate people in order to achieve affirmative action. And then this is the last slide, colleagues. What we're saying is that as I've in my introduction that we are waiting for the proclamation making effect to the date of the EE Amendment Act. So it's not yet. We'll wait for the president to sign that notice reflecting the date of commencement of this Amendment Act. And then after that, we will also publish the final EE targets for implementation. Now we cannot publish it because under which law that is in operation. We cannot. We're waiting for the president. That's why also we still making broader consultation. We've republished. We say our stakeholders look at the proposed targets, give us any submissions. We have now given you 90 days, no more 30 days, to look into that, scrutinize, submit your submissions. And then what will happen there, upon the proclamation of the effective date of the Act, the Amendment Act, what we'll do also as the department, which is our tradition, will go on EE awareness campaigns, roadshows, workshops in provinces like we do on an annual basis, and share with you the issue on the implementation of the EE, of the sector EE targets. So we cannot leave our clients because this is going to also affect your EE plans, because once the final targets are out for, we publish them for implementation, we'll have to review your EE plans and align your EE plans with that, with the targets that has been set by the minister, which is more of your goal. You will be setting your annual targets so that we move forward with transformation. And then on that note, I'm done with my presentation. Program Director, thank you very much.
Thank you for that information, for sharing, and I'm grateful that that connectivity just really kept on with us, and then up until towards the end, I was actually quite a bit nervous there. We will indeed, I think I've seen quite a few questions are saying, will you be able to share some of the questions? Indeed, we will actually be sharing some of the questions indeed with you. But I'm looking at any of the questions and I'm looking at my participants list and I'm going to be checking. Do I have any verbal questions before I go to the chats? Are there anybody that's got their hands up? I'm looking at mine. If I can't see you, just say hello and then I'll hopefully see. Is there any questions that you want to raise verbally, guys? Okay, while you're still thinking. Yes, let me see who that is.
It's Muriel.
It's Muriel. Hi, Muriel. Go
Hi.
ahead. I'm gonna take 3 questions at a go. Go ahead,
Okay,
Muriel.
so I wanted to know, just for planning purposes, is it best to advise people that, you know, by at least by the 1st of September, when the window for submissions opens in 2024, all of the changes here should be implemented by companies?
Okay, thank you, Muriel, for that. Let me take another one if there's any. Let me take another questions. Muriel, thank you for that. Anyone else? On the verbal?
Or while we're still waiting, can we
While-
just respond on
Go-
question?
Respond to that, and Director Lefika will go to the chat one just now.
Okay. Yeah, the issue is that who's that who was asking the question? Muriel.
It's
Yes.
Muriel.
Let's the most important thing is that with the amendment, let's not confuse them now, Muriel. What will happen is that since we are about to, if let's say for example, the notice date is signed for implementation of the Amendment Act, is done. I mean, it's signed by tomorrow. What will wait for that 90 days? Remember, we have published the sector EE regulation, EE targets for your public comments. Therefore, 90 days ends in somewhere in May. Therefore, we will be going out on the road shows in July, September. And then that is where we will be guiding you to whether to go and amend, align your EE plans with that. So the issue is that now, if it kicks out, we'll go out on the roadshows, share with you, and then therefore you have already have the plan. It's just a matter of going to align them, and also we give you all the necessary template. That remember, the EA2 will also be different because it has been impacted by the amendment. But currently, just stick to what you have now until we go out on roadshows. We'll share with you. We've got your database that come. Let's show you how you're going to effect or implement this target. Thank you. But now you just wait for us. Thank you. You don't have to make any changes to the plan.
Thank you, Lefika. I'm going to ask you 3 questions from the chat. We've got Freak that said, will white females be included under female designated group in the draft sectorial targets? So keep that one as well on your bag. Let's go to the next one. And then we've got another one from Petro N. Hi, Portia. Given the critical importance of the session, should we shortchange in trying to fit? Okay, so Petra, got you that. And please come back to me if there is, you still felt that there's anything that wasn't covered in the presentation. And then we will share the presentation once again, Basetsana, I think as we said. There's a few other questions, I think from Daphne Klopper. Do you have the data disaggregated further between males and females in the presentations? I think Dr. Lefika, you can answer that, but we did see that. Remember, you did talk about that from the difference between the old one and the new one, the first draft and the second one, that now you didn't further
distribution
into the racial one. Let me pick up on the last one before the last on this round rather, and this is from Gert. Question for the ending: is there officers from the Department of Labor in each town that can assist companies with their EEA Act on policies? So those are the questions. Maybe let's pick up on that. So there's a one on the males and females. I think both of them more or less are the same, those ones. And there's the last one maybe from Gert. Are there officers or inspectors in each of the towns, officers that can assist on the EEA Act on policies? Maybe answer, and then I can add from what from the spot.
Yeah, I'm not good in memorizing questions. The issue is that this is the one. I can see them from the chart one.
Yeah.
Let's say question for the ND is there officers from department to assist companies with the EA Act on policies. Yes, we do have inspectors in different provinces, and then but the other issue is that we from the head office as policy makers, we if let's say for example, remember we are in Gauteng. If companies request us to come and do presentation on the Employment Equity Act, they normally send us on request. We do come. And also for your e-forum members, we can come and do presentation to share with them, capacitate them with their roles and responsibilities. Yes, in provinces, we do have inspectors that can help you with the issue of policies. And also, it's also open to us. You send us email. If we cannot reach you there, we can do Teams and then do presentation to you. That is how we do it. So do we have data
Yeah, just go to the one before that one. There was another one that you jumped. The one that says, do you have data designated further to male and female?
I'm going to that one.
Okay, cool. Thank you.
Yeah, you see under that presentation, there is a mail whereby now what we have done is that we set the targets on males and females. So we disaggregated the data so that we can set the targets on male and females. And the issue is that in the previous one, we were saying under males, we were saying African, colors, whatever, and put the percentage. No, now we just say designated groups. And then we put male and female. What we're trying to do is that you as a company, when you do your own analysis, the question might come, the outcome might come and say that, no, Africans are overrepresented. White females are underrepresented. So what are you gonna do on that one? We say address the groups that is underrepresented. That's why at the end of, the republished one, we put designated designated groups, which include white women in that definition. And then the other one.
Okay, let's go to the next one. And I'm going that, I'm reaching that.
Can I also say, there was another one, she asked if white women fall under designated group. The law has not changed on that one. They are included as designated groups, as I've defined it, as it includes blacks, that is African, colored Indians, women that is including white females inside.
Okay.
And then the other one was
there's a one Emagambele. Public commentary were more impactful on the regulatory paragraph 3.1.4. We thank the minister for taking into account the unique sector dynamics from the 23 to 24 regulations. Sorry, my screen is jumping around.
Sector targets plus EAP. Is that a comment? That is more comment.
I think it's a comment, maybe. Emma, is that a comment? Emma, you still with us there? Okay, so it's saying that from 23 to 24 of the regulation of the I think it's a comment. Got you there, Emma. Let's go to another one, which is Ger's question. Yes, we will send the presentation, split no question asked. Okay, we got it, Ger. We'll come back to Ger presentation.
Okay.
Will be
it also asks about, say, if there are officers in each town to assist companies.
So
I think
yes,
that
was the one. He had to get off. So you are saying, please don't forget to answer that question. So we've got another one from Emma that says, please explain equal protection clause as a major implication and compliance on 4.5, financial compatibility in relation to business economics and circumstances. I hope you understand. I'm not so sure if I do, but maybe you do. So it says equal
But-
protection clause.
Please explain equal protection clause as a major
Emma? Yeah, as a
implication.
major implication and compliance on 4.5, which equals financial compatibility in relation to business economics and circumstances.
I think
Sister Emma, are
maybe-
you with us? Can you
maybe-
explain? Maybe let's make sure we hear you well.
I think maybe is you see under 4.5 is that we have listed those justifiable reasons
Okay.
that yeah, which covers more in particular the impact on business economic circumstances. The company might not be doing well and unable to address the issue of underrepresented groups. So we understand that as one of the major issues that companies have been impacted by the COVID-19, and therefore they still try their feet to stand up and move. Therefore, financially, they might not be viable as such.
Okay, got you. Okay. There's another one, and the Lefika from Faisal that says, probably a serious question. How do we determine the person's color if it's not obvious when whether the person falls into an Asian, Indian colored category? Is this reflected in the ID? What if somebody was previously disadvantaged and tick those boxes, but insist they are white or black and don't want to be reported as any other color? How does that affect the sector targets?
Yeah, remember the issue of identifying or whether you are Indian, Asian, colored categories. That thing is an issue from Home Affairs issues. So that is where we have taken this. I mean, the most important company will be, department will be Home Affairs. It's where people have been classified there as whether they are colored, Indians, whatever. I mean, if they said that, is this reflected on their ID?
Yes.
Remember, someone says that, okay, people, as someone, you see Yolanda's one there. Can you see Yolanda's one at the bottom?
Okay, let's go down to Yolanda's one. Have people have to classify themselves in terms of race when they complete EEA1? I thought EEA1 was actually disability.
Yes, it was disability, but it's fine. And then she said that, what if someone was previously disadvantaged, but insists they are white or black and they don't want to be reported? But the issue is that you will have to go and argue with Home Affairs. We're here dealing with the final product, whether when the person from the ID, if identified in a company, remember, like for example, in government, where there are forms that you complete when you want employment. You are said whether you are male, say it, are you colored, are you white, black, whatever, then African, then you tick those ones. But if people want to change the issues, then I think they will have to have verification, or evidence from the Home Affairs that they have gone under those processes to change themselves from being colored to Indians.
Okay.
That is more of, yes.
That's more of the Home Affairs issue.
Yeah, it's a Home Affairs issue. And then we should not try to confuse the system, more in particular companies that are trying to achieve and say that Masilo, tomorrow I see that we don't have enough Indians or colored in organization. Then I say that, no, I'm no longer African, I'm a colored because I see opportunities. So people should not try to beat the system, but verification and evidence must be produced. Thank you very much.
Thank you. And I think, further to that, employees does not want to classify themselves. I think we've spoken about that. That answers the same questions about the classification more being in the Home Affairs. I think the EEA1 is for race, gender, and disability, and that's the one, I think, more for disability. But yes, we hear you. There's, I think, EEA2 and EEA4. It also covers race. Okay, that's Sambo also mentions that.